On the 11th of August this year, between 4 and 6 p.m., during a panel discussion on the outcome of the vote of no confidence against President Zuma, Mr. Udo Freuser, one of the panelists, alleged that former President Nelson Mandela said in 1996 that Mr. Derek Hanekom was an apartheid agent. Mr. Hanekom objected to the statement as false, and as the program was live, it was not possible for the presenter to verify the correctness of the statement. As thus, ANN7 has subsequently investigated the claim by Mr. Freuser and can confirm that it could not be verified and is therefore false. ANN7 unreservedly apologizes to Mr. Derek Hanekom for the harm suffered and hereby unconditionally retracts the comments by Mr. Udo Freuser. We're going to our first story. The High Court in Pretoria dismissed the Democratic Alliance's application to compel President Jacob Zuma to implement the remedial action recommended in the State of Capture report. The court highlighted that the DA failed to show harm if the Commission of Inquiry is not appointed immediately, and compelling the president now would mean he will not have his day in court. Earlier, President Jacob Zuma argued that the Public Protector's remedial action has been suspended because he has taken the State of Capture report on review.
The application by the Democratic Alliance, in which it seeks implementation of the remedial action 8.4 taken by the Public Protector, is hereby stayed pending finalization of the review application under case number 9.1139.16. 2. The applicant, the Democratic Alliance, and the second respondent, Public Protector, are ordered to pay the cost of this application, which shall include the cost of 2 counsel. I hand down the judgment. In my view, it will not be in the interest of justice to direct the President to implement the remedial action prior to the review court having finalized the constitutional dispute raised by the President. I say that it will not be in the interest of justice because once the President appoints such a commission of inquiry, or even before he does so, he will be entitled to challenge the decision compelling him to do the appointment. This will result in parallel procedures based on the same issues, namely the review and the appeal against my decision. In my view, it will not only be a waste of resources, but may very well amount to abuse of legal process. Secondly, I inquired from applicant's counsel that what will happen to the Commission if the review court sets aside the impugned remedial action. I did not get a clear answer, save to say that it will stop to function.
We now have to wait until the court engages in the review application at the end of next month. But the crisp question is why, despite having on a number of occasions promised to appoint this Commission of Inquiry, has President Zuma not done so? And we find a pattern in the President's actions of constantly frustrating the orders of the Public Protector, as was the case in Nkandla, and we would like this review application to come on as quickly as possible so that we can then get to the bottom of what happened in state capture and get this Commission of Inquiry appointed.
And joining us in studio, Oliver Dixon, social political analyst, Adil Nchabileng, Transform RSA president, and Professor Barry Hanyane, political analyst and a professor with the University of the Northwest. Professor Hanyane, good evening to you and our guests in studio. Welcome. Let's start with you, Prof. If the DA's application to compel the president to implement a judicial inquiry with immediate effect, was that in the interest of justice, considering there was already a review process in place?
Good evening, Cindy. Good evening to your studio guests and, of course, your viewers out there. It would have been very difficult to see this going through today, and I think the judge made it clear that in keeping with the letter and the spirit of the law, it becomes important that a review process is given a chance to see the light of the day, and we're likely to see that before the end of next month. That, for me, made sense, and the way he went by justifying his judgment in saying that to safeguard state resources in particular, it was important that the process of review is given a chance first, and rather to avoid the issue of duplication of legal processes.
Our panelists, whether it was in the interest of justice to try and expedite the implementation of a judiciary inquiry.
If the court says so, then it must be so, right? In this instance, justice is often substantive, but sometimes procedural. and administrative. In this instance, we can say it's definitely in the interest of justice procedurally and administratively, and that's important because here we're talking about, as the judge puts it, a duplication of processes, a duplication of resources, and that's wasteful. And I think it's important to respect that. The substantive question, in which is what the DA is complaining about, is, but the president has been delaying this thing time and time again, even though he's been promising. That's not a legal question, that's a political question. The president needs to go and make a political decision, which is a different conversation altogether. But a legal conversation, the court is right, the DA must wait. We must also, it's just a month, we must wait for the review process to finish.
Yeah, but I don't know if the delay could be political as opposed to the president wanting to exhaust all other avenues and mechanisms in his defense, which is legally permissible for all of us. So yes, you may say it's delaying tactics and whatnot, but at the end of the day, he's got that constitutional right to object to something that he doesn't agree with.
I think, good evening to all the viewers. This is a very interesting outcome. For many months, DA has been winning cases unnecessarily, and people were getting to start to believe that actually the judiciary system is under capture directly, by the way, from the DA, because every court case that has been brought forward by the DA has actually been won by the DA. But coming now to the procedural process, it is indeed true. Remember, this matter is related on the basis that the public protector issued out last year a remedial action saying that there should be a commission of inquiry that looks into particularly the issues of state capture. And in this case, the judiciary, the remedial action stated specifically that a judge, Chief Justice, must actually be appointed to be the one who chooses and who actually appoints the judges as well as the investigators on the commission, which is actually a dereliction, completely a move away from the norm of how we know commissions of inquiries being actually taken around. In this case, the president is the person, by the way, who chooses in terms of who sits as preside as the judge. Secondly, the aspect of the remedial action cannot be prescriptive. That is why currently there is a high court application that says there must be a review of the remedial action, and once the review has been completed, then only can the state capture commission come into effect. So what DA missed to understand, and in this case, James Selfie should have understood before he even wasted the resources of his party as well as the resources of South Africa, and again particularly the resources of a public protector, by going to court and applying for something that already was a secondary step if the first step didn't succeed. We know that in October the application for the remedial action review is coming in. And once that application has been had and has been satisfied, the judgment has been given, then only then can the second step proceed if they are still dissatisfied with the judgment coming out of the High Court.
Well, I can almost say with certainty that they're dissatisfied, but clearly we now know that you cannot force the president or force the remedial action on the president, Professor Hanyane, primarily when they encroach on his constitutional right, or rather the constitution of the office as to who he must appoint for the judicial inquiry. I think this is something that the erstwhile public protector did not anticipate would be a sticky point.
Cindy, this is a very interesting issue. I mean, let us not forget that this is a young democracy. Much of the key provisions in our constitution will no doubt be subjected to tests and various tests, either through courts of law or through political transactions in Parliament and elsewhere. It comes as no surprise that for once, here you have a public protector report that says, look, as a president, Mr. Zuma, you yourself are found to be in the wrongdoing. Therefore, legally and otherwise, you are not privy to a position where you can establish this commission. Have the Chief Justice in the form of Mogoeng to handle that matter so that the rule of law and some measure of impartiality is achieved at the end of the day. It's up to the president now to play well to that game or continue to be stubborn and insist that constitutionally he has the right to do so. But again, his own position is compromised in this instance.
A response from you, Adil, do you think that it is delaying tactics or again something that procedurally that is permissible?
It's not a delaying tactics, and actually there's a miscomprehension here. Remember that the president of the country is the president of the country, and Mr. Jacob Zuma is Mr. Jacob Zuma. The application, in terms of the remedial action, the remedial report said that there must be a commission of inquiry extended. And within the commission of inquiry, they must look at the aspect of state capture. And the other aspect that is not coming forward here is the state capture report cannot just be an aspect of what we refer to as a state capture. It must be an expanded state capture, which we had already, as Transformer SA, requested that the terms by which that state capture report must be expanded and cannot be narrowed down to key individuals that have been targeted by the public protector at the time that the report was released. So this particular issue refers directly to the matter relating to the report itself, the manner in which the public protector made a strict prescription to say, in order to circumvent the president, the only way to do it is to make sure that you issue out a remedial action that says Chief Justice Mogoeng should be the only one who has the power to appoint the judge, and as a result must have the investigators. So what is the role of a president in his presidential capacity when his roles are conferred very clearly, and that says that commissions of inquiry must be appointed by the president and judges must be selected by the president. So that is one aspect that has been missing. So in terms of the presidency, there is no stubbornness on the presidency. Let's not fool people and create an impression that the president is stubborn. The application brought forward to say that there must be a remedial action review means clearly that certain aspects of the remedial action needs to be analyzed and particularly reviewed. And once that review has been satisfied, then the commission of inquiry in terms of state capture can be brought in.
All right, but let's look at whether the erstwhile public protector, and of course this is what the president is arguing, that she'd overreached and encroached on his rights as to who to appoint for a judicial inquiry. In her argument, saying that because he's implicated, by virtue of that, he may not be impartial or objective. So if that is what stands in what the president can and cannot do, the public protector or the courts can't change that.
Prof. Berry is incredibly correct to say that we have an incredibly young democracy and all channels and procedures and guidelines will be tested vociferously. And this is just one of those. It's important that we concretize just exactly what the reach of institutions are, particularly Chapter 9 institutions. And this case is important for creating that clarity. Just like the Nkandla case was important for creating some clarity towards it. So I think it's important that we exhaust this process. But importantly, delay tactics. To what end is the president delaying? Because he can't run away from implementing the remedial actions. It's just that certain elements, as Adil put it, needs to be reviewed, right? The fact remains, and as the court put it in the Nkandla case, that the remedial actions are binding. They may not be binding in full scope, but the remedial actions to some degree must be acted upon. And this is what's important here. So the president can't actually run away from acting on it. It's just that it's reviewed just exactly what the remedial actions should be in terms of what the law allows, what the Constitution allows, and then act on what the Constitution allows. So the constitutional dispute in this instance is that can the public protector proclaim to the president exactly who he must appoint? That is a big question that's contentious at the moment, and that needs clarification. So I think we need to exhaust that process to find clarification on that issue. Yeah. And only after that issue has been established to be clear, then we can say, President, you are delaying if he doesn't act on that.
Yeah, but Professor Hanyane, we've also seen with Advocate Busisiwe Mkhwebane that there is no absolute agreement on the binding nature of the remedial action, as she tried with extending the mandate of the Reserve Bank, and in this case the president taking the state of capture report under review primarily on it encroaching on his executive duties in who to appoint in the judicial inquiry. Do you think that even after the review process is completed, that we may come to the point where the president would be forced to implement the remedial actions as they stand?
Cindy, it's a bit difficult. I think the issue here is that we should not shy away from the fact that politically as well, there are certain activities that are taking place in that foyer. For instance, you have pressure mounted by the alliance partners, you have pressure within government and elsewhere. All of these issues may very well lead to influencing whatever outcome comes up. Let us not forget that come December this year, we have the ANC election conference. That in itself may have some measure of bearing on this issue. So safe to say, let us wait and see what next month holds. Whatever outcome, which by the way may swing to either way, and if it swings negatively on his side, then he has no choice but to succumb to the pressure as per the suggestions of the former PP's report.
Anil, are you of that view? Because I mean, you've argued very strongly that it's almost sacrosanct in terms of what the president in his executive powers and duties can do. Because now you'd open the floodgates where the next sitting president could be taken to court or whatever remedial actions. If the public protector were to say he must step down, for example, you don't even need an impeachment process.
Similar to the question of what actually the public protector brought forward on the South African Reserve Bank case. And it was actually found that her remedial action had to be completely ignored, all right, in this case. So what we're looking at here right now is the public protector's issue of actually issuing out some of these remedial actions that actually contradicts particularly executive role and duty. The president, irrespective whether people like it or not, is the executive of South Africa. He runs the entire executive. From the head of state, he is the one with the conferred powers and responsibility to appoint a judiciary of commission of commission of inquiry and make sure that they follow principles that are actually aligned. So that is the commission aspect of it. Then comes the second aspect of it. The state capture report itself is problematic. That report was a draft which was not even fully completed because there were elements of the report that needed to be expanded and ensure that we look at what it is when we define what state capture is in South Africa. So to say President Jacob Zuma right now is delaying and playing a delay tactic is a lie. There is no such a thing. They have made an application to say we need an expansion of the scope, one. We need an expansion in terms of the aspect of the priority, the review to say the remedies cannot prescribe as to who must actually be the appointing personnel, in this case being the Chief Justice Mogoeng Mogoeng. You cannot do that. So they should have tabled the report and then say the presidency should actually start the commission of inquiry and must appoint a board. Remember, the president does not sit and actually become an influencer on the judges or the investigators on the commission of inquiry. Yeah. So let's not create an impression that the president is in derelict of duty. It is not the case. They are following the processes, they are reviewing the case, and they are thoroughly going according to the laws as it is required from a South African point of view.
Yeah. Well, why don't you see this as a compelling enough reason to seek clarity so that, one, there's harmony, and secondly, to also protect the powers or the office of the president without having to open certain doors that could question the next leadership or next administration?
So the interesting part about, and directly to that, about the next president coming in and what it means for that. The interesting part about this report and any public protector report coming out and any Chapter 9 institution report, you can go look at the Human Rights Commission reports and these sort of things, is that it's comprised of two elements. It's comprised of a political element and a legal element. Oftentimes, the political element and the legal element are not in congruence. So it sounds politically nice, but it's not legally permissible. So let's look at what happened in the report on the Reserve Bank. Politically, it sounds nice to expand the mandate of the Reserve Bank, but her making that call was not legally permissible. So we may agree with the politics, but we may not all. But the legal ramifications are very sacrosanct, and we need to respect those things. And I think we are yet to establish in the Public Protector's Office just how to make those things.
So you agree that this is not necessarily a delaying tactic, but it is something that is procedurally, legally permissible for the president.
No, if it's a delay, let him qualify how.
No, it's not a delay tactic. It's certainly not a delay tactic. Like I said, the procedures needs to be exhausted for us to get clarity on it. Obviously, those who agree with the political nicety.
But you meant dashing now.
No. I said earlier. What I said is what I said. It's seen as though it's a delay tactic because politically it sounds like the right thing to do. Look, personally, as I'm sitting here, I would like the president to wake up tomorrow morning and say, "I'm appointing this commission of inquiry." Here's why. I think it's high time in South Africa that we find clarity.
How can the president appoint when we know very well that the president in this case has actually been recused from appointing the judge as well as the investigators?
No. Whether or not the president,
a remedial action that the report says very clearly that the Chief Justice Mogoeng Mogoeng must be the person to appoint the commission. So how do you say the president has done a derelict of duty when he was not even cited?
No. That's not the claim. That's not the claim.
Yeah. So what he's saying is that the president could take the remedial action as it stands.
The president wants to take the remedial action, but the report does not permit him. You see, so that's one of the things that we must engage on.
And whether or not the president appoints the person to head the
commission of inquiry. Because the remedial action says Chief Justice must appoint? Because
Thank you. So the Chief Justice has not appointed. The President says, look, we have a problem because the remedial action is erroneous on its sense, because it needs to be reviewed so that elements that were actually misprescriptions should be reviewed. Just like what Oliver just said now, that in the report of the South African Reserve Bank, as it was given, certain powers that the public protector conferred upon himself were not powers according to what it should have been. So you cannot now go again and make a U-turn. Cindy was saying that you are mandacting on this issue.
There are two issues. There are two issues here. One, it's a political statement, and two, it's a legal statement. Legally, the president is entirely covered. We must learn to separate the legal conversation from the political conversation. Let's have the political conversation. What does that look like for me? Personally, I would like to have the Commission of Inquiry active by tomorrow, because it's high time that we have clarity on just who the agents of state capture are. We need to look into the financial sector and see what their role is. What are the big banks doing in terms of state capture? Those things are important to have, but we need to have the legal grounding covered, and this is where I agree entirely. The president needs to take this under review as is currently the process, and that clarity needs to come about. Politically, however, the tune is a little bit different, because in this country we don't really know how to speak about state capture because we don't have clarity on it, and precisely because we haven't had the political
This is a judicial matter and it's before a court. There's no need for political interference on this process. The courts are taking on their own processes, like what the judge says today. There cannot be a duplication of processes. There's currently a case being had in October regarding the remedial action review. That is where it's at. There's no political interference.
Let us just clear the ambiguity here, Professor Hanyane. Maybe you can intervene in that the president cannot announce on a judicial inquiry by tomorrow, as many of us would rather have it even as soon as yesterday. But because the issue is, it then takes away from his powers as the sitting head of state.
Cindy, it's very clear. Under normal circumstances, if the preliminary report did not point a finger at him, he would then be given the due constitutional duty to do so. Unfortunately, that report paints his candidacy, his somewhat of an involvement into the whole issue, not succinctly, but there, and that compromises his position. Legally, that is wrong. He should surely recuse himself, and in so doing, allow Judge Mogoeng to appoint the judge who will take care of this issue, and we live another day to receive the results of that particular commission.
Very briefly, Adil.
I think let's be clear. Professor Berry is missing the point. The DA lost the case today in respect to having tried to actually circumvent the process by forcing courts to make a decision and overlook an application that is currently sitting in court. This is what was argued today. So we're not talking about President Jacob Zuma and his not performing of his actions, and particularly the state of capture report. That is not the discussion right now. It's the DA lost a case, and that is what must be actually done. And the DA has now been given a legal cost whereby they must pay costs, as well as they must make sure that the public protector contributes the cost with regards to bringing this unnecessary, fruitless, wasteful expenditure application to the courts.
Yeah, separation of power at least prevailed now between the judiciary and the state. And in your view, this is the correct decision that the court could make?
Legally, yeah, entirely. It's the correct view, and we need a lot more of these sort of cases to establish precedents and concretize just exactly what the roles of institutions are. I think, importantly, especially with the Chapter 9 institutions like the Public Protector's Office, we need a lot more clarity, because we're going to be a lot more frustrated, specifically because our democracy is so young and we're dealing with such dense and complex issues like the structure of the economy, the structure of the legal system, and just what the roles of other institutions are. So the sooner we get sort of clarity on this, I think it's important. The DA lost entirely, and it's silly that they actually took this to court because they knew they were going to lose in the first instance, given just that they had to wait. Just like the rest of us, we're waiting till the end of October to get that clarity.
All right, as frustrating as it might be, because we'd want to break the news first,
yes,
etc. But we all have to wait. Thanks indeed, Oliver Dixon, social political analyst, Professor Berry Hanyane, political analyst and professor with the University of the Northwest, joining us on the line. Adil Nchabileng, president of Transform RSA. To stay with us, we take a quick ad break, and of course, the ANC decides, coming up with Mfundo Mabalane just after this.